The next case is Peskin-Shepherd versus Blume. This is a 15-minute mini oral argument on the application. That means, Ms. Alberts, you may reserve, or you may attempt to reserve some of your time for rebuttal. And if you are ready, you may proceed.
Good morning, Your Honors. I'm Jennifer Alberts, and I represent the appellant in this case, Ms. Nicole Blume, and I'd like to reserve 2 minutes, if possible, for rebuttal. This case poses two significant and separate questions regarding conversion law. The first is whether a lien itself is personal property that's capable of being converted. The second question is assuming that the conversion action cannot concern a lien itself, but must instead concern the collateral of the lien or the proceeds from the sale of the property, whether there can be a conversion action if the debt secured by the lien has never been reduced to a sum certain. So the Court of Appeals majority erred in this case, first when it determined that the lien itself was the personal property that was subject to the conversion action, rather than the proceeds. The most obvious problem with the conversion of the lien itself is that this is a statutory conversion case, and statutory conversion requires not only that there be personal property, but that the personal property was converted to the converter's own use. As Judge Gleicher noted in her dissent, the lien in this case was not converted to Nicole's own use. If any property was converted to her own use, it was the proceeds from the sale of the real property. And the reason that it matters is because although Michigan does not have any case law specifically about the conversion of a lien, it does have case law about the conversion of money. The proceeds from the sale of a lien are money. And so it is well established that in an action for conversion as to money, conversion can only lie where the plaintiff was entitled to specific or identical monies. This court should reverse and hold first that the Court of Appeals erred when it determined that the lien was the personal property that was converted. And second, when it determined that conversion could be had in this case because the lien secured an amorphous debt in this case, and it was not specific and identical money. In the alternative, this court should hold that Peskin-Shepherd was ethically barred from seeking treble damages from a client for her unpaid attorney fee, which essentially quadrupled the attorney fee debt because she had the conversion damages, trebled, and the breach of contract damages. If nothing else, this court should at least reverse the trial court's calculation of damages. It's important to note that the implications of the trial court's calculation of damages in this case are fairly absurd. The lien in this case, like an ordinary attorney charging lien, attached to all property awarded to Ms. Blume. That includes personal property. So if Ms. Blume sold a couch for $100 and didn't give that $100 to Peskin-Shepherd, under the trial court's reasoning, she would be liable for triple the entire underlying debt of attorney's fees, $150,000.
Let me interrupt. When I read this, I kept getting bogged down and blocked by my life experience here of when you close on a property, if there's a lien, the title company always makes sure it's paid off. That apparently didn't happen here. And I guess the question I have is this lien still, did it survive the sale of this property? Is this lien still on the property with the new owner holding it?
It is not, Justice Zara, and the reason is because Peskin-Shepherd didn't record her lien. So part of my policy argument in this case is that an attorney doesn't need a conversion lawsuit in order to secure payment for their fees. She could have recorded the lien, and then the title company would have ensured it was paid. And it was her failure to record that got us into this position in the first place.
So, go ahead, sorry. No,
I guess is the lien useless then now?
I would say that the lien, it's arguably useless as to this real property when it wasn't recorded because it's not enforceable against a good faith purchaser because it wasn't recorded. But it would have been very simple for it to be recorded.
So, and is it also the case that, does Attorney Redmond still have a lien on that property? Did that survive?
So it's my understanding that there was litigation to remove that lien because that lien was recorded. So in order to, I don't know exactly the details of that litigation, but it was removed in some way.
And given that that lien was recorded, wouldn't it take priority over this unrecorded lien? I know we're asking you property questions that like are not, were not what we asked you to brief, so welcome to
That,
law school property class, I don't know.
that may be true, Your Honor, and I'm not certain on that because I think that her lien was recorded after, after the other lien.
Was never recorded, so not after,
Yeah.
before.
You're correct. I do think that her lien would take priority, but because it was removed, it wouldn't take. I mean, something happened, there was litigation, and that lien was removed. It wasn't what was actually paid with the proceeds. So I guess ultimately, it wouldn't really make a difference because that lien was no longer existent. I don't know the details of why it was removed. It would have taken priority if it still existed. So going to the definition of conversion, conversion is defined as any distinct act of dominion wrongfully exerted over another's personal property in denial of or inconsistent with the rights therein. Now, I would argue that this is consistent with the property, the collateral itself being the subject of the conversion, and the rights therein could be lien rights, but it's not the lien that is the subject of the conversion. And part of the reason that matters in this case is because conversion can't be had for real property. So the land itself couldn't be the subject of a conversion action. All of the cases that the Appellee cited in this case that involved liens were all where a lien was on property that wasn't real property, which is a bit distinguished from this case. But in addition, to the extent we're talking about the proceeds and calling those proceeds personal property, I think that Michigan law dictates that that cannot be had based on the lack of certainty regarding the lien in this case.
Because the lien referred to the property among other proceeds, is that?
So this lien was very amorphous. It was just a sentence in a judgment of divorce that said, plaintiff's attorney, Peskin-Shepherd, shall retain a lien on the assets awarded to plaintiff, all assets, including plaintiff's interest in the Escanaba property, to ensure payment of attorney's fees. So it's not tied specifically to the Escanaba property, it's all property.
Right.
There's no number as to what the value of the Escanaba property is expected to be. There's no number as to the debt that's being secured. So someone looking at this judgment of divorce and selling the property wouldn't even know how much goes to Peskin-Shepherd. Obviously, they can, eventually an amount was put on these fees when it went to litigation, but Nicole Blume could have contested, for example, the reasonableness of the fees. That amount could have changed. It only really became a sum certain once the conversion action was filed and litigated, because that's when an actual amount was put on the debt by a court. There's several Michigan cases that we've cited in our briefs where the only one that the majority of the Court of Appeals relied on as essentially allowing what happened in this case was Warren Tool Company. But in Warren Tool Company, by contrast to this case, the letter specifically set out, this is the amount we're going to receive, this is the amount that has to be paid. And I suppose I'd also like to note that if there's no statutory conversion in this case, for example, because she couldn't have converted the lien to her own use, that would negate both the treble damages and the award of attorney's fees, which is a significant difference than what the trial court allowed. I'd like to speak briefly on the damages calculation in this case, once again, just because I do believe that the damages calculation in this case is possibly the most absurd ruling of the trial court. I do think that that this court should, at the very least, if this court chooses not to grant leave, enter a peremptory order reversing the damages calculation and stating that the value of the property that was sold is what should be the damages in this case. So the $39,000 is what should have been the damages, not $50,000, because the underlying debt could be 5 times as large as the amount of proceeds to which the lien holder should have actually been entitled. And lastly, I would like to discuss the ethics issue briefly. So, attorney ethics, Rule 1.5 prohibits a clearly excessive fee. And the Appellee and the State Bar did both chime in and say that this is completely separate from a conversion lawsuit because one's a tort and one's a breach of contract. I do not believe that the ethical guidelines are that limited. In general, an attorney needs to be cautious in their dealings with their client because they have a fiduciary duty to that client. And that places, I think, ethical obligations that go beyond simply not contracting for an unreasonable fee. So, for example, in order to even get a security interest with a client, you must fully disclose the terms of the security interest in a manner that can be reasonably understood by the client. The ethical rules, Rule 1.8 in that instance, stress that it's the attorney's obligation to ensure the client understands what's happening. And the American Bar Association also has canons that say that generally an attorney should not sue a client unless it's necessary to prevent fraud or gross imposition by a client. So it's not simply a matter of an attorney must only be reasonable when filing a breach of contract lawsuit. I think that using a client's poor judgment to obtain quadruple the fees that you contracted to that client for is an ethical violation. At this point, if your honors have any questions, I'll answer them, and otherwise I would just reserve the rest of my time for rebuttal.
Okay, you may reserve your time. Good morning.
Good morning. Joanna Abramson on behalf of Appellee Alisa Peskin-Shepherd. The central issue in this case is whether established Michigan law regarding conversion of intangible property, including liens, applies to an attorney lien granted by a former client, incorporated into a judgment, and then destroyed by the client's sale of the collateral and use of the proceeds for her own use. Peskin-Shepherd asked this court to conclude. The answer is yes, and to either deny leave or affirm the Court of Appeals decision. The appellate panel below agrees that an attorney lien is an intangible interest subject to conversion. The majority held that Michigan law already recognizes conversion of intangibles like attorney fees. The dissent agrees that Michigan law should recognize this, but disagrees that it already does. Strong policy considerations, including the expanded use of intangible technologies in commerce, support the application of conversion law to intangible interests. Attorney liens are no different than any other intangible interest. This issue is critical for all attorneys, especially family law attorneys, who often only get paid from the sale of marital property after the divorce, well after providing the client with months or years of service. The trial court's factual findings in this case have not been appealed. They include that the debt amount was settled between the parties. Secondly, that Ms. Blume understood the effect of Peskin-Shepherd's lien on her property and committed multiple acts of fraud to destroy that lien. And thirdly, used proceeds to pay her personal debts. So there is no question on this record that Peskin-Shepherd was victimized by Ms. Blume's conduct. The Court of Appeals correctly concluded...
When I look at the statute, it relates to conversion of property. And our case law initially was tangible property. And now it seems to be expanding to intangible property like intellectual property. I'm having a hard time finding a lien to be property. You even called it an intangible interest. I don't think intangible interests are covered by the conversion statute, only property.
The statutory conversion includes within it the common law definition of conversion. The definition in the statute of conversion is the common law definition, which was defined in Aroma to be dominion wrongfully exerted over another's personal property in denial or inconsistent with their rights therein. So personal property, the question is whether an attorney lien or any lien is personal property. And that was established way back in 1929 that real estate mortgages are personal property, and they are intended or evidence of a lien upon real estate. So if a real estate mortgage is a lien and personal property, what we are saying is an attorney lien is similarly personal property and therefore subject to conversion under the statute.
But the statute also requires that you convert it to your own use. Can you explain to me how it is that Ms. Blume converted your client's attorney lien to her own use?
Yes, I can.
As distinct from just selling the property out from under her?
Yes, I can. The own use requirement is an additional requirement under the statute. And this court has already defined what own use means when conversion is occurring. And it said in the Aroma case that requires a showing that the defendant, in this case Ms. Blume, employed the converted property, in this case the attorney lien, for some purpose personal to her interests, meaning Ms. Blume's interest. So in the case of this lien was intended to exert leverage at the time of closing such that Peskin-Shepherd's attorney fee would be paid. Because Ms. Blume did not disclose to the title company, and by the way, she had an opportunity to do so. There was an affidavit that she signed that specifically asked her for whether there were recorded or unrecorded liens on the property. It said security interests or unpaid services, so she could have and should have disclosed it to the title company. But what would have happened is the title company would have then had to get in touch with Peskin-Shepherd and get that lien satisfied. And that's what normally happens at any closing. The title company makes investigations into what possible interests could still be on that property, even water bills, and to get those interests cleared before the closing takes place. So that is the manner in which the lien was destroyed, because it was that leverage that was lost at the time of closing. And this court in Aroma actually refers to that word leverage. In terms of the wine bottles that were being moved in Aroma, the owner of the wine bottles the wine wasn't drunk, it wasn't destroyed in the sense that we would think of it, but just the act of moving it out of the refrigerated area where the wine was stored could have been interpreted as a conversion. And that's why we are saying, or that's why the trial court came to the conclusion that it wasn't just the proceeds, and frankly, we only asked them for trebling of the proceeds, but the trial judge said, no, that's not what was really converted here. It was the actual mortgages.
Explain the quadruple fees. I mean, how would anyone, if you're a client and you're looking at a firm and you're doing this, would this be any reasonable expectation of a traditional client?
I'm sorry, could you repeat that?
The quadruple, I mean, the penalty that you impose, the quadruple fees.
The fees?
Yeah, the quadruple, the penalty was quadruple.
The penalty is to treble tort damages.
I understand.
Not the fees.
But is that something, I appreciate that, but the question is, you enact that against their client. Is that something that a traditional client would be, if I go into a law firm and, and I think that there's going to be dispute over legal fees, I mean, as a traditional citizen who's looking for an attorney, am I going to expect that? I could imagine fighting over a fee. That's commonplace. But wow, you guys, you really kind of went to town on this one.
This is not a dispute over fees at all.
I understand, but
And-
it's quadruple penalty. What I'm explaining is that it seems like this is a pretty harsh response to a
But-
client.
The legislature created that trouble damages remedy.
Right.
Not Peskin-Shepherd.
Right.
And legislative purpose of trouble damages is to penalize the converter. It is not a contractual remedy at all. It's a separate remedy that is in answer to the conduct of the client. Does the client expect that? No, but most clients don't try to fraudulently convert.
Can I ask though, and I guess this sort of gets to an attorney's ethical obligation. There's no question that the legislature has decided that for statutory conversion, trouble damages is a punishment. But for the statute, your client couldn't pursue Ms. Blume and get $50,000 on a breach of contract theory and also another $50,000 on a common law conversion claim, right? I think, and so I guess I get that the remedy generally in the statute exists and I think even arguably under 1.8, reasonably informing the client of the existence of the security interest. But the piece to me that's troubling mostly in respect to an attorney's ethical obligation is it the choice of whether to proceed under a statutory conversion claim for a $50,000 debt and end up getting somewhere near $400,000 judgment against her. That's the choice of the attorney to proceed under that theory. So even if the client knows that she's granted a security interest in not only the Escanaba house, but also her couch and maybe the grandfather clock and whatever else it is that she was awarded in the judgment, doesn't an attorney have an ethical obligation to inform her of the consequences that the attorney can then proceed to collect 3-4 times the amount of the
And
debt?
the answer to that is no, and here's why. The attorney has an ethical obligation to inform the client that she must or has the opportunity to seek independent counsel. Because at that moment, when she takes a security interest, and 1.8 addresses this, automatically the attorney is put into a conflicting situation. They are obtaining a security interest in favor of themselves on the client's property, and that presents an ethical problem. And the court and the ethics rules tried to solve that problem by saying you have to present the lien to them in writing in clear language. You have to give them an opportunity, it has to be in writing, and you have to give them the opportunity to seek independent counsel. And that's precisely what Peskin-Shepherd did. A month before the consent judgment was actually signed, Blume was sent a copy of the draft consent judgment, which contained that provision that you have the opportunity to seek independent counsel. And she explained those provisions to her both on the draft and right before she signed it.
And so is it your position then that, assuming that happened and she sought independent counsel, that counsel would recognize and could have informed her or did inform her that when you are granting the security interest, you should know that she can proceed against you as under a claim for statutory conversion based on the fact that in 1929 or whatever it is, we said a mortgage can be converted, and therefore you should know that this attorney lien can be converted and subject to this. I mean, like was it that clear when that was that your client could proceed under a statutory conversion claim? I mean, obviously the Court of Appeals disagrees whether or not this lien could actually be converted. I understand your position to say that it can and it has been, and it's a reasonable extension of existing law. But doesn't that then go back to informing the what it is that the client has a right to be informed about when they agree to the security interest by your client?
The conversion statute doesn't address liens at all. The conversion statute addresses wrongful behavior by any citizen in the state of Michigan.
It
an
addresses conversion
attorney,
of property.
sorry?
It addresses conversion of property.
Correct. But an attorney doesn't have the knowledge that their client might try to fraudulently get around a lien, any more than an attorney would know that a client in walking into their office could steal property from their office. It's not a normal circumstance.
They may not expect the consequence, or they may not expect the tortious action, but I think what you're saying is why the attorney doesn't have an ethical obligation to explain this is that you're saying it was a given consequence, that the minute that she agreed in her judgment of divorce to any number of things that is in a consent judgment of divorce, but when she agreed to the security interest, that she should have understood that if she doesn't pay her attorney fee, she can be subject to a statutory conversion claim and actually be subject to 4 times the amount of her debt, or more, in theory.
Depending on what she actually converted. In this case, the tort damage only arose because she committed conversion. It's not a normal consequence. An attorney, anybody should know that if there's a lien on any property that they own, whether it's a car or whether it's a piece of real estate, they should know that they hold that property subject to the lien holder's interest. And that
But counsel, I would love to go back to what sort of Justice Bernstein was talking about. Aren't we different than a car dealership because of our ethical obligations? I mean, I understand your argument. You're saying we should have the same rights as everyone else when it comes to a lien. But I am having a hard time squaring our ethical obligations not to charge, or collect an unreasonable attorney's fee. How can we go from a $39,000 fee to, this, very, very astronomical fee?
the fee, which was the fee that was owed was $50,000.
Okay.
And we have never claimed that that fee was anything but. The problem is that we have a statute in the state of Michigan that if you do this particular wrong, you will collect treble damages, and that treble damages could be very small, it could be large. We, as attorneys, have an ethical obligation to advise our clients what this lien means. It's a security interest. The lien itself says that it's there to ensure payment of the debt.
Counsel,
And
can
in
we move back to the lien for just a second? I'm sorry, we've talked about the ethical, I think everyone's aired where they feel about the ethical obligations and how complicated this is. Can we go back to the lien itself? My understanding is an equitable lien on real property travels with the property. Why doesn't your client still have a lien on the property? Somebody else owns it, so you're not going to get it from.
On this piece of property?
Yeah, why doesn't it travel with the property?
Well,
If you think it's worth something, even though it wasn't unrecorded.
it is unrecorded, and as to the third party, it is not, we can't go after an innocent buyer.
But it travels with the property, so whose problem is this, right? Doesn't an equitable lien on real property travel with the property? I mean, I'm actually asking, I tried to find my property book and I couldn't.
You burned it.
I did.
The property, the Escanaba property is done because the lien was not recorded. So
So whose fault is it that it was not recorded?
recordation of the lien is not a requirement under Michigan law for an attorney lien. So
But does it affect the value of your interest in the property?
No, it does not, because the attorney lien was a consensual lien between Peskin-Shepherd and her client. That lien survives, as between the two of them, the attorney lien survives.
But it might survive to all the couch and the grandfather clock, and I don't know, whatever. I mean, it's a pretty, if you have a lien on my herd of cattle, and I sell one of them, you probably still have a lien on the rest of them, right? Can you charge me for conversion for the value of the entire herd if I sell one?
Yes, and we have case law, in Supreme Court case law, that says it is an act of destruction of your interest for which it is a conversion. And that is the Sleeper case.
I'm going to pass it to Justice Viviano. Go.
I guess Justice McCormick covered, the chief covered, I guess, most of what I'm interested in. I am interested in the fact that your client didn't reduce the lien to a dollar amount and didn't record it, and I'm wondering whether that affects our determination of whether this lien should be considered personal property or not. In other words, it's not a very valuable lien, right? A valuable lien would be one that's perfected.
No.
One that's recorded, and that one that would then, be there at the closing presumably, and then it would require more from the other party than simply not advancing the funds.
Yes, Justice Viviano, the trial court, the divorce judge, Judge McDonald, has ruled on those two issues. The divorce court said, A, this lien is valid, and there's no law in the state of Michigan that requires recordation, and B,
I understand it's not required. I mean, it's not, your client didn't break the law by not recording it. She just made the lien a whole lot less effective and therefore probably a whole lot less valuable. So like if she wanted to sell her interest in collection to a debt collection company, they would say, well, did you record it? And she'd say no. And they'd say, well, my offer for your lien goes down from $30,000 down, we'll give you $250 for it then. Because it's not, you can't do anything with it, right? So the value of that personal property, if that's what it is has plummeted because of your client's inaction. I don't understand how you can contest that.
the lien itself is a lien between our client and any of the assets, the marital assets of the client. And so the client, in this case, had no other marital assets at that time that were awarded, really, other than the property in Escanaba. And if one,
Your client, obviously looking back, would have reduced it to a dollar amount and recorded it, no?
the trial court said that it had been reduced to a dollar amount. It was an exact dollar amount that had been arrived to between the two parties. The Blume paid on an exact dollar amount, account stated, that was established between the parties from before the consent was entered in.
So
At
then
the
it would have been
time,
easy to record it.
pardon me?
Then it would have been easy to record it?
The Peskin-Shepherd could have recorded the entire judgment, but that would have also been unkind to her client, who she, at that point in time, had no knowledge that she had acted fraudulently. She was trying to make payments in a slow way, so she didn't record it. She attempted to get her to sign a short form lien so that she wouldn't embarrass her client with all the details of her divorce. But she could have recorded the entire divorce judgment, and the fact that she didn't record it shouldn't be blamed on the victim of this fraud. The recordation requirement did not in any way affect the validity of the lien, and the trial court determined that there was always an exact amount owed, and that was paid on, and there was no question at summary disposition that that amount stood at $41,098.68. So to say that there is a amorphous amount owed out there is absolutely not true.
I'm just focused on the fact that there's no document at the Register of Deeds file that says that I'm owed this amount of money, and the court has entered this as a lien against this property, so that all the world knows if there's a sale of this particular parcel of property and whatever buildings are on it, that the sale can't be closed until this lien is taken care of, paid off, right?
It would have been more helpful to Peskin-Shepherd, absolutely.
And is routinely done by attorneys.
I'm
correct?
sorry?
And is routinely done by attorneys who want to protect their interests when they have an attorney lien. Is that not the case?
But it's not required. And in this case, the
Does it affect
title,
the value? Does it affect the value of the lien when an attorney doesn't record it?
not at the time of sale. And the damages that we are looking at here that are troubled are the actual damages suffered by the owner of the property interest at the time of the sale. At the time of the sale, there was a definite value to that interest, and that was $51,098.68. That's what the law requires, that you examine the actual damages as it relates to the owner, not to the proceeds that were there, but as to the owner. The real cash value of that lien at the time of closing was $51,098.68. And if she
When
had
you say that amount, I guess just to clear it up, the balance, unpaid balance was less than that at the time, correct?
No, the unpaid balance
Oh,
was.
I'm sorry, the value of the property was less, the proceeds of the property were less than that, I'm getting it. my facts
That's
all mixed up.
correct, but what would have happened at the closing was either, in order to get the discharge of the lien, either Peskin-Shepherd would have accepted the proceeds amount, or they would have had to come up with bringing cash to the table, or there would have been other arrangements made. But at the time of closing was the time that this reckoning should have taken place, and Ms. Blume shouldn't have signed an affidavit that said there are no liens on this property. Because that, in addition, the recordation is one way the title company would have known. But the other way that the title and company should have been informed was by the disclosure in an affidavit that there was an unpaid service fee on that property.
Thank you, counsel. We've used up way more than your time.
Thank you.
Briefly, Your Honors, I guess I'll start with the points that the Appellee was just speaking about, which one is that the Appellee counsel said that the debt had been reduced to a dollar amount since before the judgment of divorce. Now, I think that there's plenty of evidence in the record that that's not true. There may have been a set balance in the attorney's invoices, but not only was that value not, the debt amount not included in the judgment itself, there was record evidence that there were emails, for example, between Peskin-Shepherd and Ms. Blume about possible settlement. Peskin-Shepherd had offered to potentially reduce the amount in exchange for Ms. Blume paying earlier. So if, for example, the real property was sold and Peskin-Shepherd was paid straight away, it may have been less than $51,000 that was actually paid because they were talking about settlement. Second, Ms. Blume did originally object to reasonableness. While the fee did end up being set at the $51,000, eventually, once the conversion proceedings were in play, there was an amorphous nature to that amount because of the possibility of it being reduced for excessiveness or the possibility of it being reduced because of some kind of agreement, which the parties were discussing. Appellee counsel also mentioned the conversion statute and how the statute essentially says that you will collect treble damages if this tort is committed. And that's not true. That's not what the statute says, because the statute does specifically give the trial court discretion to impose treble damages. So the plaintiff doesn't have to seek treble damages. The trial court doesn't have to impose treble damages. It's purely a remedy that's discretionary. So Peskin-Shepherd not pursuing that remedy would not be in any violation of the legislature's own mandates. In addition to that, generally, I think it's understood that just because a person who's not an attorney could do something under the law, that does not mean that it's ethical for an attorney to do that. Something may be legal and still not ethical. And so one of the rules that's fairly broad and is referred to in many ethics opinions for a broad range of issues is Rule 1.4, which is just essentially communication with the client. You have to explain every matter to the client in a manner that can be reasonably understood by the client. So the issues that many of your honors were raising during Appellee's argument about essentially shouldn't Peskin-Shepherd have communicated to the client that she could be subject to this potential consequence because of the lien when the client was agreeing to that lien? Is that part of reasonably explaining to an unsophisticated client what the lien entails? I would say that under both Rule 1.8 and Rule 1.4, the attorney did have an ethical obligation because they're an attorney, not just any business person, to inform of the consequences of failing to abide by a lien.
Your time is completed. Do you have anything to wrap up with?
Counsel, do you have any response to the allegation that your client misrepresented the true state of affairs on her affidavit at the closing?
I mean, my only response to that would be that Ms. Blume's position has always been that she didn't really understand that the lien was already present. Essentially, she saw the lien as something that the attorney would have to come up with a document and record it in order for it to be effective. So when she said that there weren't any liens, she, as an unsophisticated person, just did not understand that there actually was a valid enforceable lien. And I think that's partially because this Redmond lien was such a problem. The title company said, you know, hey, there's this lien, and they didn't bring up the Peskin-Shepherd lien. So as an unsophisticated person, she did not really understand, I think, that there was a lien, and so she did say that there was not a lien. And if your honors have no further questions, then I can just leave it at that.
Thank you very much. The case will be submitted. Thank you for your presentations.